Hi, thanks for joining me. This is Natay Dearden. I'm with the Utah State Board of Education. I'm a dispute resolution specialist in the special education section. And today I'll be talking to you about an introduction to the formal IDEA state complaint process. Today's webinar will help participants gain a basic understanding of the Utah State Board of Education state complaint process, help participants understand the LEA's and the USBE's different roles and responsibilities in this process, as well as review early dispute resolution options that LEAs may utilize in resolving parent or third-party concerns. This comes from our state code, and it just captures our philosophy in Utah that it's in the best interest of students with disabilities to provide for a prompt and fair final resolution of disputes that arise over educational programs and rights and responsibilities of students with disabilities, their parents, and public schools. As we go through this webinar today, I hope you'll see that the dispute resolution system we have in Utah does support this philosophy and that we do try to work through things quickly and in a fair manner to ensure that students are receiving the services they're entitled to. This webinar won't cover these other options in detail, but I wanted to include a small graphic just to show what other options are available to folks in Utah in terms of dispute resolution. One of the ones that we use a lot is the telephone intermediary, and that often involves when families contact me with some questions or concerns. I reach out to the special ed director of the LEA to enhance communication and really help to resolve those concerns. So that's something that's used very often. We also have the availability of parent advocates who can help parents to prepare for meetings or to even attend IEP meetings in certain circumstances. We offer IEP facilitators that are trained facilitators who can attend meetings and help families and schools work through issues or concerns that they're facing in the IEP process. We provide mediators for mediation sessions. We handle state complaint investigations, as we'll talk in detail about today, and we also administer due process hearings. So all of these options are free and available to families and schools throughout our state. I included just a brief picture of our website. It doesn't show all of the details or resources available, but kind of at the top in the middle, you'll see the form section, and those are where folks can download forms to request a lot of these services. We also have state and national resources. The bottom of that picture, you'll see parent information resources, and even though I couldn't include all of those, you'll know there is a section there that includes more information for families. So what I wanted to start out first by doing is explaining what is a state complaint. A lot of folks aren't quite sure because it's not something that's utilized as much as some of the other options I showed you. And so this is designed to provide just a little bit of background. A formal state complaint is an option that's existed for a long time in Utah, and it's a way that parties can use to resolve educational disputes. The basis of a state complaint is that it's used to communicate that a public agency, and whenever I say that, I'm talking about a public school district or a charter school, that they have not followed the requirements of the Individuals with Disabilities Education Act, which is the federal special education law, and that they're requesting an investigation into the matter. A complaint can concern one student, or it may concern a group of students, depending on what those issues are. And a state complaint is unique in that anyone can file it, not just a parent or guardian, not just a school, but any person or organization, including one from another state, may file a written state complaint. Now, the law sets forth requirements of what has to be in a state complaint, and I've included these requirements in the next couple of slides. First of all, it has to include a statement that the LEA has violated a requirement of federal or state special education law. It has to include facts on which that allegation is based, and it must include signature and contact information for the complainant or the person who's filing the complaint. The big requirement at the bottom of this slide deals with timelines, and that is that a complaint must allege a violation that occurred not more than 1 year prior to the date that the complaint is received. I often receive calls or concerns from families that deal with issues that happened several years ago or even longer. And unfortunately, the state complaint process does not allow investigation into those matters. So it has to have occurred in the last 365 days prior to the day the complaint is received. We also need additional information depending on if it's in regards to one specific student. We need information such as their residence, the name of the school the student's attending. We may also have homeless students that it may concern, and so we need another way to contact the student as well as the name of the school they're attending. We need a description of the nature of the problem of the student, including facts, as well as a proposed resolution of the problem. The proposed resolution is an important part of the state complaint process because it allows the party, which is often the parent or guardian, to kind of articulate things that they would like to see to fix the issue, and it kind of gives the school district an opportunity to see what they're asking for and may help with early dispute resolution or may help the investigator as they're working out the outcomes of the complaint. I've included just a little snapshot of the state complaint form. That's available on our website. I can also fax it or email it or send it in a letter to folks who need it. This form is not required, but it helps the parties capture all of the required information that we need. And so if we receive a complaint that doesn't have a form, the party who submitted it just needs to be aware that we may be contacting them in case it's missing any information, and that may delay the investigation a little bit. We receive state complaints in a few different ways. We can receive them by in-person delivery, by U.S. mail, or by fax. And I've included our contact information on this slide. It's also on our website and on the form itself. We do not accept state complaints through email, and that's based on a desire to maintain student confidentiality and not transmit information in a manner that is not secure. If I do receive a complaint over email, I immediately contact the person filing and just explain to them the ways that we do accept submissions, and we move from there. If a complainant is unable to file in writing for reasons involving accommodations or difficulty with that, they can contact me or their school district for assistance. Now, this next section is called State Complaint Limitations. There are some things that sometimes are included in a complaint that are outside the bounds of what we're really able to investigate because we don't have jurisdiction over them. And so I wanted to review some of those as they pop up sometimes. Occasionally, we will get complaints that include allegations of discrimination based on race, creed, sex, age, color, national origin, or marital status. It's important to recognize that there is a forum for complaining and resolving these issues, and that is through the Office of Civil Rights in the Denver Regional Office. When I get complaints, either formal or informal, regarding these issues, I will refer parents to this office as they're the ones who have the authority under the Americans with Disabilities Act and Section 504 of the Rehabilitation Act to really investigate and resolve issues of discrimination. We also sometimes get complaints regarding educator misconduct, and in that case, parties are referred to the Utah Professional Practices Advisory Commission, or UPAC. That is an office housed within the USBE, and they are charged with looking into and investigating those issues. Lastly, we'll sometimes receive parent concerns regarding violations of the Family Educational Rights and Privacy Act, or FERPA. And that often deals with student records and concerns that things were transmitted inappropriately or confidential information was disclosed when it shouldn't have been. The way to formally request investigation and complain about those matters is through the Family Policy Compliance Office, which is a federal office within the Department of Education. We also will not investigate allegations that are not submitted in writing. As you saw above, we have a lot of requirements around what needs to be included in a complaint, so we can't receive that in a way that's not in writing. Allegations need to be signed. Inquiries that seek advice and clarification of parental rights, but which clarify no official action is being requested, are not seen as formal complaints. And an example of this would be I occasionally have parents call and ask for advice or clarification of their rights, but they don't file anything and they're not asking me to investigate from a state level. And so we view that as an inquiry. It's not a formal complaint. But for LEAs listening to this, I would caution you, if you believe that a parent is coming to you and asking for a venue in which they can request an investigation or raise something to the state, allow them to understand that there is a process for doing that, because sometimes parents misunderstand and think that raising an inquiry to me or to an LEA is something that sets a formal process in motion. And without these other pieces we're talking about, it will not do that. Sometimes we do receive courtesy copies of correspondence directed to another entity that are related to the student's education. Those do not count as formal complaints. And occasionally we'll receive anonymous correspondence. Now, we're not required to issue written responses in response to an anonymous complaint. However, depending on what that says and depending on the nature of the allegations and the situation, we may look into it more as part of our general supervisory responsibility, but not in the terms of a state complaint investigation. We'll also dismiss allegations in a state complaint for the following reasons. We sometimes have state complaints that do not include allegations that are governed by any special education law, regulations, or rules. They may involve something related to school, whether it's school day, after school, something regarding the student's education, but are not special education issues. In that case, we dismiss those allegations because we don't have the authority or the requirement to investigate them. We also sometimes will see allegations that were previously resolved in another due process hearing or state complaint, and I'll talk about that interplay in a little bit here, as well as alleged violations that are 1 year or older. Some parents will include allegations that were several years ago, and that does sometimes provide context for the investigator, so it can be helpful, but it's not something that will be investigated in terms of the 1 year time period. There are occasions when a state complaint has kind of a mix of allegations. Some are relevant, some are not. And so if we dismiss issues that are aligned with some of the ones above that I just described, but the other allegations remain, we'll proceed with investigating those remaining allegations. Now, as I mentioned, sometimes a family may choose to utilize a couple dispute resolution options at the same time. They may have filed a due process hearing request first, and that may be ongoing, and then they decide to file a state complaint investigation. When that happens, what we do is look at whether there are overlapping issues. If the state complaint and the due process hearing have any of the same issues alleged in them, the due process hearing kind of takes precedent and will decide on those issues, and the state complaint will be on hold in terms of those issues. We have something that alleges all the exact same issues, the whole investigation will be put on hold. If it's just some, the state complaint will proceed with the independent issues, but it will be paused in terms of the issues that the due process hearing officer is looking at. Once a due process hearing decision has been made, if there are any issues remaining, then those will be resolved through the complaint process. It's a little confusing, but the important thing to remember is if they involve the same things, due process will kind of take precedent and decide on those things, and state complaint issues will be held until that other process has played out. In a similar way, if an issue was previously decided in a due process hearing and the family just disagrees or wants to bring that up again, the thing to remember is that the due process hearing decision is controlling. And so it's final on that decision, and we move on from that, and we'll let the parties know when that's the case. We don't see that happen very often. However, the last sentence of this rule points out if a due process hearing officer has made a decision and the LEA is failing to implement that, a family can submit another due process hearing request or a state complaint and come to us to try to get that resolved. When an LEA receives a state complaint, they often contact me with questions about how they can resolve it in another way other than an investigation. And so I wanted to include some of our early complaint resolution options that different districts and families have chosen to utilize. One of the things an LEA can do, or a family, is reach out to the other party and say, would you be willing to have a resolution meeting in which we talk through the issues and see if we can come to some type of agreement? That's sometimes successful. Oftentimes, the allegations in a state complaint deal with issues discussed in IEP meetings. They may involve decisions that were made by the team that a parent's in disagreement. They may involve things that just aren't happening in terms of IEP implementation. And so sometimes calling a meeting and getting everybody back together at the table can help folks come to agreement and work through the issues that were in the state complaint. Along these lines, sometimes parties have a difficult time working through the IEP process. There may be miscommunication or hurt feelings going on. They may kind of be stuck in conflict. And when that occurs, it may be helpful to request an IEP facilitator from our office, which we're happy to provide, and that person can come out and help the parties work through that process and see if they can come to resolution. Lastly, mediation is a dispute resolution procedure that a lot of parties have successfully used, and that involves a mediator who's impartial, who's trained in helping folks come to agreement, and the family will come to the table with an attorney or an advocate or even just each other and work with school administrators in a smaller group outside of the IEP meeting to resolve those issues. All of those things can be requested through our office, then a facilitator or a mediator, as well as schools and families have the option to schedule a resolution meeting or an IEP meeting whenever they would like to try to work through these issues. Through these issues, a team may be able to resolve all, part, or none of the allegations. And I know sometimes it's scary or teams are reluctant to try to have a resolution meeting because they say, well, what if we aren't able to solve everything or come to agreement? And that's okay. I think the important thing is the effort and the attempt to try. In many cases, it is successful, even when parties have been arguing or disagreeing for a long time. So I always encourage a willingness to try if both parties are open to participating. If agreement is reached, the complainant and the LEA will notify me in writing, and that allows me to know that these issues have been resolved, and we'll work on communicating with the person who filed to see if they're wanting to withdraw the complaint as a result. Once we receive notification, let's say that only some of the issues were resolved, then we'll dismiss those from the state complaint. And sometimes issues may be remaining, and so the investigation will continue to look into those allegations that were not resolved. As I mentioned in the last slide, complainants do have the option to withdraw a formal state complaint at any time in that 60-day period before we've issued our written decision. That is something that we're seeing this year, especially with this change to the one-tier system, that in many cases, districts and families are able to work together. And so if they're able to come to resolution, they can submit a withdrawal form to me and we will end the investigation. Now, because a lot of folks are working toward agreement outside of the investigation piece while it's going on, I have seen a lot of agreements throughout the year, and I wanted to include some bullet points that help the parties understand effective agreements just so that they can make sure they're including all the details that would be necessary for things to move forward in a good way. And so I wanted to point out that effective agreements identify actions that will be taken, when those actions will begin and when they'll be repeated, who's responsible for completing the action, and who's responsible for making sure that action was completed. Sometimes that's the same person, sometimes it's different people to just have those checks and balances, as well as the time period of the agreement. Additional effective agreement components include a process for review when the action's completed, a plan for making changes to the agreement if needed, and what to do if a participant thinks the agreement is not being met, as well as a statement of confidentiality and the date of the agreement and participant signatures. In many cases, when these components are part of an agreement, we don't see problems moving forward. But I know sometimes parties can be a little hasty or not as comprehensive in their discussion, and so problems may arise in the future if we don't cover these different elements of what an agreement includes. And if that happens, that's okay. We can get a facilitator or a mediator involved, but just some tips as you work to that so you can avoid problems about communication or expectations going forward. So we've talked a little bit about what a state complaint is and what those options are to resolve it with early dispute resolution procedures. Now I'm going to take you through some of the processes surrounding what the investigation looks like. So once we receive the complaint, we date stamp the complaint and we immediately contact the LEA to ensure that they've also received a copy. Sometimes parents don't know about the requirement to give a copy to the LEA, or sometimes there's delays in mail or other things. And so we just want to make sure that they have it when we do. And so if they don't, we fax them a copy so that they have that in their hands. And once I know that they have a copy and we have a copy, we begin the 60-day timeline. At that point, I will assign a complaint investigator based on rotation and availability, and I'll send correspondence to the involved parties to provide notice that the investigation is starting, as well as who the investigator is going to be. Now, I have this slide as just a reminder that there are certain times of the year or certain times in the special ed process when parents are entitled to receive a copy of their procedural safeguards. And so we do send out a copy of the procedural safeguards along with this initial correspondence to the parent, because the law requires that parents receive that upon the first time that they submit a state complaint or a due process complaint in that school year. Now, a little note about our complaint investigators. None of them are full-time USBE employees. They are all on a dispute resolution contract with us, and they receive ongoing professional development training in a number of ways. Many of them participate in work groups, listservs. We have a quarterly work group call with the Technical Assistance for Excellence and Special Education Center, as well as we host an annual Utah Law Conference, and our investigators attend that. Some of our investigators are attorneys by background, others are special education administrators, and so they have a lot of experience in investigating complaints in this state as well as other states. And they often also do things such as mediation or facilitation. So they have a really good range of experience, and we appreciate the work that they do for us here in Utah. So these next couple slides will outline what our responsibilities are through the state office in terms of carrying out this investigation. So we're charged with carrying out an independent on-site investigation if that's necessary. As I mentioned before, we have state complaint investigators who do work in a number of different states, so some of them don't actually live in Utah. And in many cases, an on-site investigation isn't necessary, and so they'll do a lot of documentation reviews, they'll do phone interviews and such, but we do sometimes have them come on-site to the LEA and meet with folks in person as they're conducting the investigation. The state complaint rules want to give both parties the opportunity to submit additional information, so that includes the complainant having that opportunity, either orally or in writing, about the allegations they made in the complaint. This is an important point because oftentimes parents aren't super well versed in special education law, which is okay. The law wants to give them an opportunity to file the complaint, but then be able to provide more information so that as the investigation's going on, there may be things they think of or that they wanted to talk about that couldn't fit on the form or that they didn't think about at the time. And so the investigator works with the person who filed to really understand what their allegations are and make sure that the investigation will cover that. On the flip side, we also want to give the LEA the opportunity to respond to the complaint. And that includes giving the LEA an opportunity to propose to resolve the complaint. As I mentioned before, that can often be through arranging mediation or facilitation, but it can also just be through a written proposal that the LEA submits to the other party. We also want to give the LEA an opportunity to engage in mediation if that's something the parties want to do. The law requires us to look at all the relevant information, make a determination as to whether the LEA did violate requirements of federal or state special education rules. And really, through documentation and interviews and site visits, that is how our investigators will come to those conclusions. So near the end of the 60 days, we issue a written decision that kind of encompasses all of that. And it will really speak to each allegation in the complaint, and it will contain findings of facts and conclusions and the reasons for our final decisions. Now, kind of in the midst of getting the complaint started, I mentioned we send correspondence to the school district and to the family to let them know who the investigator is going to be and let them know the timeline. After that, the investigator will send an issue letter, and that's kind of their introduction to the parties, where they clarify the issues that they found in the complaint, and then they'll request certain actions from the LEA and the families. The families will be asked to provide just any copies of written communication between the parent and the school regarding the alleged issues and any other relevant documentation or information they may have. The burden on the LEA is a little bit bigger in terms of documentation just because they're the ones who often keep a lot of it and are responsible for producing that. And so as part of kind of setting up this investigation, the investigator will want to know who's my contact at the LEA and what's their contact information so I know who I'm working with. They'll want additional documentation that you'd often see in the student special education file. So IEPs, BIPs, evaluations, progress reports, discipline records. They'll ask the LEA for a narrative response in terms of what their response is to these allegations. And to get some of that, they'll either use questionnaires or they'll schedule interviews or observations. They may ask the LEA, did you do an internal investigation and what did you find? As well as they will want a formal response to the issues set forth in the complaint, meaning the LEA needs to either admit or deny the allegations and share facts and reasons as to why they feel that way. Now, if you're an LEA listening to this webinar, you'll know that's kind of a lot of information to gather together. And so what I'm encouraging LEAs to do is from the minute you know that you have a complaint, review that complaint and start gathering information and start doing that internal investigation and determining whether or not you believe those allegations are true or not. And so that way, when you receive this issues letter a couple weeks down the line, you'll be ready to work with the investigator in submitting that information and asking any questions or sharing anything that you feel is relevant. Now, in most cases, these state complaints have to be resolved within 60 days. There is a limited exception in the rule that says we can extend the timeline based on exceptional circumstances, but that timeline cannot be exceeded past 10 calendar days. So it's still not a huge extension. One of the reasons for an extension can be allowed for situations when the parties are engaged in mediation or another means of dispute resolution. And so if a party's engaged and they haven't finished it up, then we could extend a little bit. However, it's been my experience in Utah that as soon as a complaint is filed, LEAs and families, if they want to do mediation, I encourage them to do it as quickly as possible so that we can avoid going through a whole investigation that may not pan out because of a withdrawal due to mediation agreement. So this doesn't typically happen. We have had LEAs ask for extensions occasionally, but they're often not granted because it really has to be an exceptional circumstance. And as I've included on this slide, OSEP has found the following do not constitute exceptional circumstances, including state staff shortages or heavy caseloads, school vacations and breaks, or the use of mediation or alternative dispute resolution without agreement by parent and LEA. And so really the staff pieces, the vacations and breaks, those are tricky, but they don't warrant an extension of time. A state complaint can be filed at any time throughout the school year. So we do get some in the summer, and there are LEAs that have to respond and go through that in the summer, just a heads up. So I included a graphic that just kind of illustrates the process. I'm a visual person, so it helps me to kind of see this graphic and see how the process goes. The complainant files the complaint with the USBE and sends a copy to the LEA. That's how things get started. And so then we move to confirm that the LEA has a copy of that complaint. We assign an investigator, and the 60-day timeline begins at that point that we know both the USBE and the LEA have a copy of the complaint. Within a couple weeks, the investigator will send an issue letter to the parties requesting more information and scheduling interviews. During this time, the parties can use informal or formal dispute resolution options to try to resolve the complaint issues. At the end of the 60-day timeline, the USBE will issue a final report, and that will include conclusions, findings, and corrective actions if applicable. And then over the next year, the USBE will work with the LEA and the complainant, the person who filed, to ensure that the corrective actions are implemented. And we're going to talk a little bit about that in this next section. So this next section is called Complaint Resolution Report. When the report comes out, the written decision, as mentioned earlier, it's going to address each allegation. It's going to specify findings and conclusions. And the term findings just means findings of noncompliance. It means that the investigator found things that were violations of federal or state special education law. And as such, the LEA will be required to make corrections to those findings. And the report will have the reasons for why we came to our final determination. Just a note to LEAs listening, I think this is an important thing when you receive a complaint report. If there are findings and corrective actions, it's important to review that with the staff who were involved in the case, as well as maybe more generally staff within the LEA. I often find that can be a helpful learning experience, and although there may be some disagreement as to why the investigator came out the way that he or she did, it's helpful to really talk through and look at the issue from that outside perspective. And I found it to be a valuable learning experience in helping staff notice mistakes and do things right moving forward. We also send a copy of that decision to the LEA's Director of Special Education and the district superintendent or charter school directors so that they have a copy for their records. The written decision, as mentioned before, I wanted to hit on this third bullet, must also include procedures for effective implementation of the USBE's final decision, including, if needed, corrective actions, which may include remedies to achieve compliance. Based on investigations in many instances, what we'll find is that the school, the LEA, could benefit from additional technical assistance activities, or the teams could benefit from further discussion and negotiation in an IEP team meeting to make some determinations that come about from the investigation, as well as other corrective actions. When we have found a failure to provide appropriate services, we're also required to address how the school district is going to remediate the denial of those services. And sometimes that will include providing makeup services. Sometimes it may include awarding monetary reimbursement. For example, if the parent had to go somewhere else to get those services, as well as we need at the USBE to ensure that appropriate future provision of services for all students with disabilities will be happening. An example of this is that many state complaints allege that students did not receive services as captured in their IEP. That could include related services like speech or occupational therapy, or it might include reading or math services. And if a parent alleges that those weren't provided, and we find through the investigation that that was the case, a school will be required to provide compensatory services or something to compensate the family. And so we'll often see many of those orders. Sometimes it will be minute for minute. Other times we'll ask IEP teams to convene with the family and make a decision as to what must be provided to ensure the student receives a free, appropriate public education. Now, along those lines, when the investigator is looking into the issues, he or she may find that multiple students didn't receive services, or multiple students were kind of the subject of procedural or substantive violations. When that's the case, the school district will often be required to undergo training so that we can ensure staff and administrators are providing things in accordance with law and that they've received the training they need to make sure that all students with disabilities who may have that service in their plan are receiving it. Now, in most cases, corrective actions need to be completed within a year, but I'm including just a short summary from an OSEP Dear Colleague letter that explains there are cases that are very individual when corrective action timelines may extend beyond a year. I have seen that with some compensatory education awards where the award was so big they couldn't provide all of the hours in addition to the student's normal school day in summer, and so it stretched into the next year. And in those cases, I work with the LEA and the family to ensure that it's happening when it should by the required timeline in the state complaint report. Now, complaint decisions issued by the State Board of Education are the final action, and they're not subject to an appeal. This is a little bit of a change to what some of the LEAs are used to. Our old special education rules, so prior to October 2016, we had a two-tier state complaint system, and that started with families filing a complaint with us, but the LEA would have the first 30 days of the 60 to investigate. And if the family was not satisfied with the LEA investigation, they could appeal to us, and we would do a separate investigation in the remaining 60 days. With the change in special education rules in Utah in October 2016, we went to a one-tier state system. We are the ones who take the full 60 days now to investigate that, and as such, there is no appeal process. And so the decision is final, and if a party disagrees with that decision, their remedy is to file a due process complaint, and they can take that before a hearing officer and see if that can be revisited. So just a couple slides here at the end in terms of enforcement, how we enforce state complaint decisions. As mentioned earlier, many state complaint decisions will come with some corrective actions that need to be completed as soon as possible, and in most cases no later than a year. I and my colleagues at the state office work with the family and the LEA to ensure that these deadlines are being met in a timely manner. And I do this through documentation, through emails, through phone calls. I occasionally do have a parent contact me when they're concerned that it's not happening. Sometimes that's because it really isn't. Sometimes it's because LEA is not providing good documentation to the family. Sometimes there's miscommunication, like I talked about earlier in terms of agreements. Sometimes different folks come out of that with different expectations about what was going to satisfy that. And so I often work just to make sure that everybody's on the same page and that those things are happening. If in the future, after a complaint report has come out, a facilitator or a mediation session may be useful to work through some of these concerns, then that's something that schools and families will utilize. I wanted to have one slide on the RDA Evaluation Rubric. A lot of districts will reach out and ask, how does this affect my results-driven accountability score? Or when RDA letters come out every year, they'll say, oh, did dispute resolution impact me at all? And so I have just an excerpt from the rubric. You'll see kind of a shift from on one side, LEAs that have no complaints or due process hearings and no findings. On the other side, in 5 directing, you see LEAs who have had multiple complaints or due process hearings and multiple findings. And so that's just kind of the range. I think it's important to remember that an RDA letter is composed of a lot of different indicators, and so this is just one of many. And so I encourage LEAs to not worry too much if you get, let's say, one complaint or one due process hearing, because that will not impact your general score in the long run. However, it's always a useful time to evaluate as staff and see what could be done differently to kind of use those early dispute resolution options and ensure that we don't get to this point if necessary. So this concludes our state complaint system webinar. I hope that I've answered a lot of your questions and given you some basic details. I know the information can be somewhat technical, and so I invite you to look at the applicable sections in the State Board of Education rules, to review the resources available on our website, which includes state and national resources, as well as you're always welcome to contact me. I'm happy to explain and answer questions. I'm also happy to talk to families, so if you want to refer families to me who may have questions, I'm happy to do that as well. So thanks for your participation.